now in session.
Good morning. Please be seated. Before we begin, I would like to welcome a group of judge advocates from the 7th Infantry Division at Joint Base Lewis McChord who are joining us this morning. They're led by their senior representative, Lieutenant Colonel Elizabeth Walker. Those of you from the JBLM, if you'll stand, the court will acknowledge your coming. And thank you for being with us. Good morning to everyone else. The first matter this morning is In re Tarra Simmons, bar applicant. Shon Hopwood will have 20 minutes for his opening and 10 for response, and Jean McElroy will have 30 minutes for the response. Sorry, 20 and 10 for your rebuttal.
Good morning, and may it please the court. Because the historical facts here are largely undisputed, this case presents the court with the core question of how long must Ms. Simmons establish rehabilitation to outweigh her serious prior misconduct? We think that the answer to that question is that 6 years of extraordinary rehabilitation can overcome that misconduct. This court has said that evidence of prior serious misconduct is not conclusive evidence of present character, and the court should not retreat from its view that that rehabilitation can overcome misconduct.
Counsel, do you think that there's any fixed year that the court ought to be landing on as a guidepost?
I think the 5 years from the attorney reinstatement cases would be a good place to establish a guideline, not a presumption, not a bright line rule, but guidelines, and in part because the social science tells us that. The social science says that when someone has 5 years of sobriety, they are a very low risk of relapse. Social science says 5 years of clean conduct means a much lower risk of recidivism, and I think that's what the court should be focused on here.
Was Ms. Simmons incarcerated during any of that period?
Yes.
How much time?
And from 2011 to 2013, and we think the court should take that time into consideration.
Why so?
A couple reasons. One is you have a letter of support from Devin Schrum, who is the Associate Secretary of the Department of Corrections, who notes that when Ms. Simmons comes into the prison system considered her a low risk of recidivism, and so they did not put her into mandatory training programs. Despite that, she volunteered for those programs, and Mr. Schrum also said it's very unusual for a person in prison who's moved around facility to facility to facility to not receive any disciplinary infractions, not even a minor one. And he noted that that takes great character and resilience to go through those 2 years. And that was the first time that Ms. Simmons finally got treatment for the untreated trauma from her childhood and the sexual assaults that she was a victim of, and for the drug addiction. It is undisputed here that all of her prior misconduct, the crimes, the incarceration, and the bankruptcies, all resulted from untreated trauma and drug addiction. And so the focus should be on, we think, two things. One, has she received treatment for the trauma? Has she received treatment for the drug addiction? And is she at a great risk of relapse? And two, has she demonstrated rehabilitation? And we think the answers to both those questions is a resounding yes.
When we analyze those questions, talk to us a bit, if you would, about the standard of review. The vote, I understand, below was 6-3. Is that correct?
That's correct.
Do we pay attention to that? If it had been 9-0, would our review be under the same standard, or does the fact that it was a split vote change the way we look at it? And what deference, if any, do we give to the analysis and conclusion?
Well, if this court applies the analysis from the attorney disciplinary cases, the court has said in several opinions that it gives less weight to divided board opinions. No one here, as to the larger question of deference, no one here says that the court is doing anything other than de novo review. Everyone agrees that the board's recommendation should be treated as just that, a recommendation. The only dispute is about whether fact-finding, credibility, and demeanor determinations should be given some level of deference by the court. And our view is, if you decide to go that route here, it's not outcome determinative to this case.
I'd like to go back to the standard of review. I think that's an excellent question to ask here. I'm just looking at Fossidal, disciplinary proceedings against Fossidal, which this court handed down in August, so it's a fairly recent case. And the court said, while we review conclusions of law de novo, we give greater weight to the conclusions of the board with regard to the recommended sanction than we give to the conclusions of the hearing officer. And then goes on to say, when the board is unanimous, we uphold its decision absent a clear reason for departure. So, are you suggesting that everything about the decision is a de novo review, or just the conclusions as we held in Fossidal?
I think the ultimate conclusion about whether Ms. Simmons is admitted to the bar is de novo review and should be treated like a recommendation. The court said that in Belcher. It's never moved away from that, at least with initial applicant cases. I think the court can provide some level of deference to fact-finding, credibility determinations, demeanor, and those sorts of things. But that's not outcome determinative here, because almost all of the historical facts, including credibility, was unanimous.
I just want to make sure I'm hearing you correctly. It sounds like you're saying the issue on which we review de novo is the ultimate decision.
Yes.
All right, thank you.
Yes, and whether you want to give deference to fact findings and credibility and demeanor, that's not going to determine the outcome here. Here, all 9 board members were unanimous in the credibility finding. They said that Ms. Simmons expressed complete candor at the hearing. She expressed genuine remorse for her misconduct and articulated self-awareness about why the misconduct occurred and what she needed to do to address that.
You know, I read the record as there being a difference of opinion on demeanor. And I'd like to ask you about that. I read the majority, maybe even as considering outcome determinative, how she presented herself. And I wonder if you could talk about that compared to how other bar applicants with other felony backgrounds, usually men, have presented themselves.
Yeah, so we think that even if you accept the board's demeanor finding, that shouldn't outweigh all of her evidence of rehabilitation. But taking the demeanor finding head on, we think that it's curious because you have a credibility determination by the board majority that says she expressed candor, genuine remorse, and articulated self-awareness about why she had these issues. But then it has this statement that she had a sense of entitlement. And if you read the hearing transcript, that is simply not borne out by the record. And the board majority relied on 2 things. One is they said that she minimized her drug use in 2005. If you supply substantial deference to that, we think that is not supported by any evidence in the record. She acknowledged in 2005 that she did not think she was a drug addict, but that by 2011, when she got treatment, she realized that she was mistaken about her drug use in 2005 and that she now does identify as an addict and realizes that that's a real problem for her. So there was no evidence to support that. Then you have the statement, the unnecessary referral to the Character and Fitness Board. And we think both the bar and the board majority placed way too much weight on that. That was a statement made by her counsel in the application, and what they were trying to do was use a procedural rule which says that bar counsel has the discretion about which cases to send to the board and not. Like any good lawyer, they tried to take advantage of this procedural rule, and we don't think that Ms. Simmons should have been punished for using that procedural rule. We also think that it may be very likely that the board misconstrued her excitement over 6 years of pretty astounding achievements and just a remarkable level of rehabilitation that this court will probably never see again, because we're talking about graduating with honors, the Dean's Medal, the Graduating Student Award, the Skadden Fellowship, all of those things, her being appointed to 2 commissions by the governor of the state, and the scores of Washington State bar members who witnessed her as a Rule 9 intern, and while she interned at many public interest organizations.
You know, one thing that I think the majority opinion said about that is that some of those people had only known her for a few years. And I wonder if you could compare that statement about Ms. Simmons with letters of recommendation that have come through in other disputed cases of the same sort, for example.
Well, I could speak to one in particular. Yes, we think that if you look at the recommendations in other people's cases, especially men's cases before the board, those letters of recommendation from people that knew the applicants for 2 or 3 years were given far more weight in those other cases than they were in this case. And we think that's why demeanor is simply too thin a reed to base such a weighty decision on here. The court should be concerned most about whether she has a risk of relapse and whether she has treated the trauma. And the record there is undisputed. She receives counseling for the trauma. She regularly attends NA meetings. She has a sprawling support network of professional mentors, doctors, people in the legal community, people in her religious community, others in recovery, and they testified, Vanessa Hernandez and Rosalind Solomon both testified that they witnessed Ms. Simmons during very stressful periods of practice as an intern, and that she uses that support network to deal with the drug addiction issues.
Mr. Hopwood, could we go back to the 5 years that you started off with, which, and, you know, the period for...
And so we're going to just take a moment. We have a medical situation occurring. So we'll just pause the time. I know where we are, and we'll just take care of what's happening in the courtroom. Okay? That's fine. We'll just take a moment. It's a very full room and it's warm, so it's understandable. We'll just be sure we're all right. Still late. So please excuse the interruption. We'll continue with the question and the answer. The clock will begin again. If anyone feels themselves getting hot or overcome, if you want to just step out, it's significantly cooler in the foyer. All right, but with that, we'll continue. Thank you.
The question was about the 5 years period. I think that the period of 5 years for seeking reinstatement, it's a reasonable comparison. Is there any case law that points, or have you looked at the cases to see what's the range of time that it looks like... It's hard to measure this because it's not expressly stated in the cases generally. But I'm just wondering if the case law sheds, or what light the case law might shed on this. And I'll ask Ms. McElroy to address the same question when she's up here.
The reinstatement cases, Justice Wiggins, supply the 5 years as a benchmark for how long someone needs to establish rehabilitation. This court's cases do not prescribe a time limit for initial applicant cases, in part because the court hasn't had one of those cases since the mid-'80s, and so there's not a great comparison in published decisions. What you see in the recommendations that we submitted is that 5 years of rehabilitation is generally sufficient, was for the board in other cases and in other recommendations. Not necessarily in the court's published opinions, but in other recommendations that the board has made. We think 5 years is a good guideline for a couple of reasons. One is, again, her risk of relapse after 5 years of sobriety is very low, 14%. Her risk of recidivism after 5 years of clean conduct is similarly very low, 13%. Also, if the court were to set 5 years as a guideline, it would provide some certainty to this process where currently there is none. Currently, for someone with a prior conviction who is thinking about going to law school, they have no certainty as to whether or not they should take the risk of 3 years of law school and potentially $150,000 in tuition money, and whether or not they can get into the lawyer club.
Are you advocating a bright line rule that you would always be able to after 5 years?
No, I think in unusual cases with especially long periods of fraud that do not have as an underlying problem drug addiction and serious untreated trauma, that would present a different case. I think the court could say as a general matter 5 years is enough. And I think that would turn the board's focus from looking for the unusual case to admit to looking for the unusual case to not admit. And I think you would see a profound change in how the board handles these cases if the court were to say that.
And Mr. Hopwood, isn't our decision also needing to be informed by studies and science in terms of reentry, rehabilitation, that this really, again, we look outside of our cases when we're trying to make a determination of the risk?
Yes, and we cited some of those studies on page 21 of our reply brief. And again, all the social science says 5 years is a really good benchmark for judging whether someone has made profound change in their lifetime and whether they are at risk of relapse or risk of recidivating after the 5 years.
And what would the studies say to us about reentry and the community of support that one needs? And does Ms. Simmons have that?
Every successful reentry story I have ever seen involved community, where people get out and have community. And it's important because then they don't want to let that community down by committing new crimes. And so community is very important. You're going to be hard-pressed to find an applicant who has a greater community in the Washington legal community than Ms. Simmons.
Well, my Facebook feed would tell me that too. It's heard that a number of times. What do you think the role of social media is? Because certainly the folks who are supporting her on social media don't know the full record. But do we take note of that great public support? Or what if anything, do we do with that?
I think the fact that 3 state court judges, several state legislators, several prosecutors, and scores of Washington State bar members who have witnessed Ms. Simmons for a longer period of time than the board did during her hour-and-a-half testimony should be weighted into the court's determination on whether she has the character and fitness necessary to practice law.
I'd like to go back to some of the studies and some of the information that was provided, not only in the briefing, also by amicus, in terms of the connection between relapse recidivism and a job and housing, and again, this broader community support.
Yes, all of those things matter for someone coming out of prison and getting their life back on track. Again, every successful reentry I have ever seen involved community. It involved a sense of purpose. Ms. Simmons has that. She has a dedication to serving the less fortunate amongst us. And I think this court can have great confidence that she will uphold the very best traditions of the bar because of that community and the support of lawyers in Washington who have written letters of support for her. You have a letter from Dean Annette Clark who said 28 years she's been filling out and attesting forms as to students' character and fitness, and she has never been more certain about anyone's character than Ms. Simmons. I think you can trust those findings by the people that have worked closely with her.
So can I ask you this question? Because, and I'm mostly concerned about the advocacy for kind of a bright line rule, or and we have a lot of things to consider. The period of time in which a person was offending, and here though she's a juvenile, and I understand the history of trauma and childhood abuse, but it was about a 20-year period based on the board's finding. We have the cases like Belcher and Wright, and typically one of the challenges the court has in whether it's a character and fitness or an attorney discipline matters, we're looking for some comparability in these cases. So I want to be clear, are you asking us to just say the court got it wrong in Belcher and Wright? I mean, there was a lot of similar evidence in the Wright case, letters from prominent community members, a brief period of probably mental illness-induced criminal activity followed by a substantial period of rehabilitation. And the court said no, I think 3 times.
Yeah, so we think those cases are distinguishable in part because in both Wright and Belcher had contemporaneous issues. In Belcher, it was the applicant had mental illness that the doctor said he may never recover from. And so the court there was concerned about whether he had the present character necessary. In Wright, it was 2 things. Mr. Wright, the court found, did not express genuine remorse like Ms. Simmons did, and he was committing the unauthorized practice of law why he was trying to become a lawyer. Here you don't have those contemporaneous issues.
Well, and let me be clear, I'm not asking as much just the factual question, but you're saying 5 years. I mean, they had longer periods of post-incarceration rehabilitation, but if 5 years is to become a new presumptive, and it does align with the ability to reapply after denial of, after even disbarment, what does that do to our ability to look at, are we just saying just put those cases in the dustbin of history and we've got a new era?
No, I think you distinguish those cases and recognize that Ms. Simmons' record of rehabilitation is different from those two cases.
So it just becomes one more case in the...
Yeah, and I think the court could handle it two different ways. The court could say, on this record, 6 years of rehabilitation outweighs the prior misconduct, given all of the facts in the case. Or the court could come up with the 5-year rule from attorney reinstatement cases and say going forward that that should be at least a guideline for the board to use in deciding the ultimate question about how long is long enough.
Can I ask you, when you say 5 years, what are you measuring the 5 years from? What's the start point?
Plain conduct, and in this case I would say evidence of no use of substances, and some sort of demonstrated acts of rehabilitation. And so I think here you would start the clock from 2011 when she is in prison, she's receiving treatment. I mean, the honesty is it is harder to make these changes in prison than it is out. And so I do think you should take into consideration that she did all of this programming and treatment while in prison and received not even a minor disciplinary infraction. That's pretty remarkable, given what I know about the prison system. And so I think the court should take those 2 years into consideration and evaluate that as to her level and what she has established as far as her record of rehabilitation.
We've had some cases that are purely financial problem cases, which is always a concern. Most attorney discipline cases we see are financial matters. So how do you address that? Because that's fairly recent. I mean, I understand there are explanations for the cause of the financial distress that are related to the criminal conduct, but that's certainly not a 5-year-old problem.
Yes, but I think the bankruptcy's here, and I don't think maybe the bar will dispute this, maybe they won't. Everyone acknowledged that the bankruptcies were part and parcel of her criminal conduct and drug addiction, and she only has the bankruptcies after she is incarcerated for 2 years, of which she can't pay off her debts. And so the bankruptcies are very much tied to that conduct from 2011. You have evidence in the record that since 2011, she has not taken out new debts. She has a plan in place with her family's finances, and she's not had any financial troubles after she finished her period of incarceration. And so I don't think that the bankruptcy from 2015 should be counted in that time period, since it was part and parcel of her incarceration and her drug addiction.
Counsel, your time has expired.
Thank you.
May it please the Court? My name is Jean McElroy. I'm the Chief Regulatory Counsel for the Washington State Bar and Counsel for the Character and Fitness Board. I also served as Bar Counsel in the hearing in this matter. We are hoping from this case to achieve clarity on the standard of review in this case, and regardless of the outcome, the ultimate decision on admission or denial, we would like a statement from the court that the Character and Fitness Board did not act arbitrarily in making its findings and reaching its conclusion. And I believe that review of the complete record will establish that that is, in fact, the case, that they did not act arbitrarily.
Let's talk about the complete record, and let me pose a few questions. Because when I look at the board finding, and actually I'm going to go to the finding on page 14, there's a footnote about media contacts. I really want to give you a chance to address this. Is why would Ms. Simmons' response to a media inquiry be treated as a negative factor or as something that somehow was interpreted in a negative way? And why would she have any obligation to come back to the board about that if the media contacted her? I really need to understand that.
Sure. I think it's explained in the footnote itself, where it says that the board therefore disregarded any such information. They pointed it out. It was everywhere. You couldn't help but see it, but the board said, okay, it's there. We're not paying any attention to that. That doesn't affect our decision.
And what else did they say, though, about her not coming back? Nor did she seek to supplement the record with any media information.
I think that is to explain why they didn't consider it. They didn't consider it in this case. They said they disregarded it, and I think that was appropriate. It wasn't part of the record before them in the hearing.
Well, why even note it? It wasn't part of the hearing. Why even put it in here?
I don't know why, other than it was everywhere. Honestly, you couldn't have avoided it. If you had, it was on many of the major radio stations. It was being published in various bar journals.
No, but it wasn't part of the board hearing.
Right, and so they disregarded it.
And so they had to put it in a footnote and mention it.
I don't know that they had to put it in a footnote. They did. And they specifically said that they disregarded it. So they did not base any of their findings on those media articles or the fact that they existed.
And then I really read the transcript very carefully because I wanted to know what was it about demeanor or attitude that seemed to come out as something negative, because the chair kept asking Ms. Simmons to even speak up because she was speaking so softly. So what is it specifically in the record that goes to demeanor and attitude?
So the record in this case is, yes, the transcript, and the transcript is significant, but there is also a record that is almost 1,000 pages long of documents that were submitted jointly by Bar Counsel and
of which I did review.
Yes, and the applicant. So in Ms. Simmons' application to the bar, and regardless of what has been presented today in this hearing, the summary statement that she wrote was very clearly written in her own language, her own words, and it said, an unnecessary referral to the Character and Fitness Board would add little to assure the Washington Supreme Court of my current fitness and good moral character necessary to practice law, which is more than fully documented in this application and supporting materials. And she continued, a referral to the Character and Fitness Board would be particularly harmful in my case because I have been awarded a Skadden Fellowship to serve the needs of a vulnerable population. If you look at the transcript, the Skadden Fellowship was mentioned more than 30 times during the course of the hearing, and it was clear that that was being done as a way of saying, we have to get this result, it has to be done quickly, because this fellowship is out there that she has earned and she can't lose it. If you go to the Skadden Fellowship website, it appears that Ms. Simmons is still listed there as a 2017 recipient of the Skadden Fellowship, that she's providing direct services in her community.
But that shift came after all of this. Initially, she stood to lose it. So let me just ask you a couple of questions as a follow-up to your remarks. When she says unnecessary, wouldn't you think that the voluminous obstacles she's overcome would be sufficient proof? So wouldn't it just be a normal response to say, you could probably decide this on the record of my criminal history, my conduct, my law school grades, everything I've achieved and accomplished. Could you not decide it? Wouldn't that be a reasonable inquiry to make?
She was in the record. There's a statement from Ms. Simmons that she consulted with John Strait before she, who was a professor at Seattle University and does advise applicants for character and fitness, and that he told her to expect that this would be a difficult case to make. And so I don't think it was a reasonable assertion on her part, and other applicants do not make that kind of assertion.
Has anybody ever in the state of Washington received a Skadden Fellowship?
Not to my knowledge.
Well, in the record,
as we heard in
no.
the record, yeah, right. As we heard in the record, no. And I don't have any reason to dispute that. I don't have any reason to dispute that it's prestigious. It obviously is. Is that a reason to change? Did the Skadden Fellow awarders know the entire record of Ms. Simmons' history? And I think you'd have to say no, because the entire record of her history didn't even become clear until the course of the hearing. She never mentioned anywhere in her application materials or anywhere else that she had abused and was addicted to methamphetamine in 2005 for a period of 6 to 9 months, where she was her counselor. She's been in counseling for 20 plus years for trauma associated with her childhood and for addiction issues. Her counselor at the time told her she should check herself into a treatment center, and she did. This was during the time that she was writing her application for her petition for a governor pardon for her previous criminal convictions, her juvenile convictions and her 2001 assault conviction. And so that information didn't come out until the hearing, and during the hearing, she expressed that she didn't understand why that would be important for the Character and Fitness Board to take, or this court, to take into account. I think if you look at her various applications over the years, you would find that when she was applying to law school, she noted that she was addicted to narcotics for a period of 10 months, and that started at her father's memorial. If you look at her application on her Rule 9 application, she said she was addicted to narcotics and amphetamines, and again implied that occurred at her father's memorial. During the hearing, she said that she had been using prescribed narcotics and amphetamines for a period of 2 years before her meth use in 2010, that happened at a Thanksgiving celebration with a family member. She walked in and saw an aunt using methamphetamine, and despite the fact that she knew, and she testified to this at the hearing, she knew that the likely outcome of this request would be her addiction to methamphetamine based on her previous history. She asked the aunt if she could use some of the methamphetamine, and she did, and then this addiction occurred. This was a choice.
So let's compare her disclosures and her forthrightness about her pride in her awards and her fellowship and her accomplishments with other applicants, all of them male that I've looked at, who have been in a similar situation. Has she been more or less forthright or equally as forthright as them? And in terms of coming forward with her prior misdeeds? And has she been more or less prideful or boastful than the men have been? And if it's about the same, why treat her differently?
So how I would answer that question is to take a look at a review of the Jimmy Wright admission case. Mr. Wright was in law school when he committed a murder too. He was convicted of that. He was sentenced, went to prison, and when he came back out, he reapplied to law school. It was a difficult process, but he did get readmitted. And in the meantime, after that, he achieved the same type. Now, granted, this is before social media, so there wasn't the ability to get this kind of recognition on the same scale. But he had awards, he had local politicians and state politicians, he had law school professors, he had members of the bar in general, he had many, many letters of support, and he brought those to the court, to the Character and Fitness Board committee at that time, which then went to the Board of Governors. And I believe he went through 2 separate hearings, and one of the factors that the court pointed to in saying, well, yes, he has all of these accolades, but he didn't express remorse during his hearing. And in addition, the court talked about how he had, in his application, slightly misstated or underrepresented some of his work, which was, he said he worked as a researcher. He didn't say a legal researcher. And when they explored this during the hearing, it came out that he had done some legal research, prepared some incorporation documents for 2 clients, which never got filed. He didn't consider that to be the practice of law, and that was a major factor in or appeared to be. It was cited by the court as a major factor in their determinations, that minimization. Same issue with Belcher, Mr. Belcher, who had a mental health issue.
If we're doing comparisons, I thought the board unanimously determined that Ms. Simmons was forthright about her prior conduct.
So Yes, and I don't think that's contradictory. I believe the finding specifically says she was forthright at the hearing. They observed her demeanor, and at the hearing she was open and forthright. And as I say, that is where we finally, hear the story about the 2005 addiction and treatment. And it is the place where we hear about some of these other factors. And we, in the course of this record, there's also the fact that she didn't disclose her juvenile crimes in her application to Seattle U, which Seattle U said that wouldn't have made a difference in the admission decision.
Well, Ms. McElroy, if you can seal your record, don't you assume, and doesn't the average person assume that if a juvenile has a record sealed, that requirement to disclose doesn't exist? And didn't she explain why she didn't?
She said that was the reason why. However, again, I point you to what she said about what Professor Strait told her before she applied to law school, which was she had to be open and honest, make full disclosure. That was her testimony. So,
because she didn't follow up and say, well, does that include my juvenile record that's been sealed? Wouldn't most people assume you don't have to disclose it?
I don't know that there is a most people situation here. I'd say, we review over 1,000 applications a year. Many people disclose everything. You wouldn't believe the things they disclose, from juvenile convictions to the most minor of traffic offenses.
Right, but we all work very hard now on juvenile sealing issues because we want people to have a second chance. We want people to not have to disclose the fact that they may have a juvenile record. Wouldn't you agree?
Yes. And the question was, have you ever been convicted of a crime? That doesn't mean, has it been sealed? It means, have you ever been convicted?
And did the law school hold that against her?
No, the law school did not. And I've said that, and it was clear in the record and the transcript. The law school said it didn't make a difference in their admission decision.
How do you, when you're looking at comparable cases, when you look at somebody who grew up with all of the privileges and advantages with supportive family environment, and committed a serious crime, compared to somebody who struggled from the outset with addicted parents and difficult situation and victimization, what do you do as you're looking at those two who both rehabilitated? How do you treat those pasts that are very different? One who had all the chances and gave them up, and one who never really had the advantages to start with.
Yeah, there's nothing about what the board did in this case or the findings or how I'm arguing here that is intended to in any way discount the struggles that Ms. Simmons has had, the process that she's gone through, and the efforts that she's made. She is very clearly on the right trajectory.
You'd agree it's remarkable.
It is remarkable, and the board acknowledged that as well in making its findings. But what the board was faced with was this pattern, repeated patterns of misconduct. You have the juvenile convictions when she was 13 and 14. You have one for theft, one for possession of stolen property, one for assault second degree.
When do you stop measuring the pattern? Mr. Hopwood was suggesting a 5-year term, and he had a starting point for that. Do you have an idea about when you start measuring the period of rehabilitation?
So I think that depends on when you think full rehabilitation has occurred.
So you would start measuring from full rehabilitation?
Full rehabilitation. Are you fully, have you completed all of the requirements that you're on? Are you currently under some sort of monitoring or probation requirement, which Ms. Simmons is? Have you acknowledged everything that you've done? Have you disclosed your history? Do you own your addiction history and treatment history? Where are you in that process? And I think even most addiction counselors would say that that is a very important factor. Can
I ask, when you say full rehabilitation, do you mean that someone who hasn't, for example, paid off their legal financial obligations would not be deemed, you wouldn't start the clock on measuring rehabilitation?
No, I think if you're making payments, if you're trying to achieve the things that you need to achieve. In Ms. Simmons' case, her legal financial obligations were paid by someone else. And even though she didn't pay her other debts before her bankruptcy, and even though she'd been given additional time to pay off that loan, she paid that loan off faster and in larger amounts than she needed to. And so...
Who paid the legal financial obligations in the case of everybody else who's been convicted of a crime and thereafter applied for admission?
So in Mr. Hopwood's case, which he talked about, he paid them, and he paid restitution more than the court-ordered required restitution. In other cases that were cited to the court by counsel, the unpublished cases, Cleotis Floyd assumed sole responsibility for the restitution of all of the defendants in his cases.
My question was who paid it. In my experience from being an advocate and representing criminal defendants for over 25 years, quite often they had to depend on the family member or the loved one who had the stable job to do that.
That's correct, and I can't tell you with specificity who paid each of those. I can tell you that in those cases, those people who had been charged and convicted went above and beyond their court-ordered obligations.
And Ms. McElroy, just because I want to make sure that this record is completely accurate, didn't she pay off her legal financial obligations? That is, somebody lent her money to pay them off, and she paid them back, so they were paid by her. Is that correct?
Yeah, I believe that's what I said, and yes, that is what the record shows.
A question about one of the conclusions on page 21 of the majority opinion.
Sure.
It's at line 12. I guess I just don't understand what this goes to, what aspect of the decision we have to make, what it goes to. It says some of the attitudes she expressed in the record and at the hearing signal that her acquired fame has nurtured not integrity and honesty, but a sense of entitlement to privileges and recognition beyond the reach of others. What does that go to about her character and fitness, particularly compared to page 17, where it says the board sees that she is now expressing healthy awareness and attitude about both her misconduct and her personal responsibility for the misconduct, and that she accepts full responsibility and expresses genuine remorse. So I don't understand what that finding is related to.
I think it's related to, they give one example, which is the example of the unnecessary character and fitness hearing. When looking at a record of this type, the repeated conduct of, serious criminal, dishonest and violent criminal crimes, separated by years of no criminal conduct, in repeated periods of drug addiction, separated by significant periods of no addiction, repeated financial problems, separated by periods of no financial problems. You look at a record like that, and then to make the argument that a character and fitness hearing is unnecessary, the board felt that's the one example they give. The other example that I would cite is
what does it go to, though? Is it
I'm sorry.
Because she shows that she understands, that she has a healthy awareness about her misconduct and her personal responsibility. So it clearly doesn't go to that, I guess. I mean, is that so? And the other is whether she takes responsibility for her actions, and they say, yes, she does, full responsibility, and then expresses not only remorse, but genuine remorse. So I don't quite get whether it matters that she thinks this is unnecessary. Does that go to her lack of awareness about her conduct, her inability to accept full responsibility, or to be remorseful?
The way I would read that statement is that it goes to her lack of understanding the nature of character and fitness hearings and the requirements of good moral character and fitness to practice law, and that it might go to a sense of an idea of what is the appropriate, what is it that you have to have in order to be successful in the practice of law. I wish the board had given more references. They cited the one example. The other example I could identify out of the record was the lack of expression of remorse, in the sense the word sorry was used once in terms of I'm sorry for what happened, but yet the Skadden Fellowship is mentioned more than 30 times. And I think the board just, if you look at that record, I think that's what the board might have been referring to.
Did the board feel slighted, like they weren't being given enough respect for the importance of the job that they do?
I doubt it. I doubt it, because the board recognizes that everything they do comes to this court. Every single character and fitness case comes to this court and is reviewed, and that this court can change their recommendations. So I don't think they have some sense of a huge, like this is our turf. Don't go into our turf. But I do think they recognize this court's role, and it is an important role.
So you said at the beginning you were concerned about the standard of review and the arbitrariness standard. Could you address, I guess, what you think the room is in the court's decision to modify a standard?
I think that the court has previously said that it will give considerable weight to the findings and conclusions in the lower decisions. Now, in those cases, that was the Board of Governors making those decisions. But in this case, it's the Character and Fitness Board, which this court has specifically delegated significant authority to in the court rules. The court has specifically described the factors that they want the board to look at. And the board, in its findings, went through every single one of those factors, every specific factor, every aggravator, every mitigator, looked at the essential eligibility requirements, heard all the testimony. And I think when you look at that kind of a record, there is some deference that is owed to particularly demeanor, credibility calls. Those are the kinds of issues that the court typically will give some weight and some credibility to when they're reviewing a decision from a lower fact-finding, testimony-taking court.
It's not right. I would agree that the board went through each of the factors that are listed in the APRs, but you continue to defend or attack, depending on how you look at it, the fact that she would have mentioned the Skadden Fellowship 30 times in a hearing. And I guess I just wonder if you think it's reasonable for a person who as a child had been assaulted, raped, homeless, on the street, hungry, in prison, addicted to drugs, finally gets a fellowship that's actually going to give her an opportunity to be paid to serve the people that she wants to help. Wouldn't that be something you're so very proud of? And there you are at a hearing that's finally asking whether you have the moral aptitude or fitness to serve. Wouldn't you want everybody to know you got this fellowship? Nobody else in the state has ever gotten this. Wouldn't you be proud? Might you mention it even 50 times? Isn't it reasonable?
I definitely think it's reasonable to mention it. I think it's definitely reasonable. It would probably be mentioned more than once. The court has asked me to point to things in the record. Those are the things that I can look at and say, this does sort of imply a sense of, like, these people have decided I get this fellowship, and so therefore I shouldn't have to go through this character and fitness process. That was the implication of all those comments. And so I do think it might go to that factor that the court has described. I wanted to take...
There have been a couple of questions about treatment of men or the way men's cases were analyzed, and we have a woman here. Were there any women on the Character and Fitness Board?
Oh, yes, there were, and I don't remember the exact numbers, but the Character and Fitness Board is usually fairly diverse in its gender makeup, certainly. There are attorneys who come from all sorts of backgrounds. There are criminal defense attorneys, there are prosecutors, there are public members who come from educational backgrounds, public service, government service. We have people who have served as pro tem judges. We have people who have worked as ALJs. We have people of color. We have people with disabilities. It is a pretty broad wide-ranging group of people that hears these 12 to 24 hearings a year that they see, and the thousands of pages of record that go with them.
Who appoints the members of that committee?
The lawyer members are appointed by the Board of Governors, and the public members are appointed by the court.
Counsel, can I ask a question about your office's position in this case? I understood that you didn't take a position.
That's correct.
And so I wanted to ask you, of course, typicality can be anything, but is it typical for your office not to take positions in character and fitness cases?
It is. And, it's interesting because the role of bar counsel in these cases is an interesting one. And I found this quote in the Edelman case at 79 Washington 2nd, 725, at page 726, which I think is the best description I've ever seen of the role of bar counsel in these hearings. And it says, the role of bar counsel is not, strictly speaking, that of a prosecutor. His obligation is to present the board all of the material facts, that is, all of those facts coming within his knowledge and proof, bearing on the ultimate and controlling question of reinstatement, which this court must decide. And it says, while bar counsel does not function as a prosecutor, his role is not devoid of adversarial qualities, and he is obliged to inquire into and test the veracity of the petition and the evidence and recommendations supplied by petitioner in support of it. So we typically do not take a position, but we do have an obligation to try to make sure that the information that's coming out is accurate and well supported, and try to establish whether there's other information available as well.
Ms. McElroy, as a follow-up to Justice Wiggins' question about the board, can you possibly just tell us what kind of training do they get?
So the board gets various training during the year. Every year at the beginning of the year, we give them training about the character and fitness process and how it works, about the rules, the factors, so on. The cases, the two published admission cases that exist, character and fitness cases. And so we do give them that training. I guess I would say, as a comparable matter, what specific training is given to juries or to judges when they first take the bench, before they ever sit. And so I think it's a question, it might be, there may be more training that could be done, but they do hear all of these cases, and they do bring this variety of backgrounds. Like I said, there are always at least one or two public defenders or previous public defenders or criminal defense lawyers on these boards, and they bring a background that is very aware of those issues. I did want to talk about one other factor that came up, and that is the statistics. There is case law that says you shouldn't look at a statistical consideration specifically, but when you look at what was cited by Mr. Hopwood, 5 years of sobriety is a low rate of recidivism, 14%, and yet in Ms. Simmons' case, she had her addiction issue in 2005. She had 5 years of sobriety, and then she made the choice to use the methamphetamine. So she did recidivate, even though she had those 5 years of sobriety. And in her, in the 5 years since conviction and the low rate of recidivism, in Ms. Simmons' case, she had her juvenile convictions. She had 10 years with no convictions. She had an assault 2 conviction in 2001, in which she enlisted other people to help her in the assault. She had 10 years with no criminal convictions, and so she, again,
the period
demonstrated.
And what we get to consider, because I would think that being told after overcoming so many barriers and progressing so far from where she was, that being told you don't get to sit for the bar would be a major blow and might be something that could lead to a relapse, if anything would. Can we take into account whether she's relapsed since that date, or do we only look at the record as it was closed at the time of the decision by the board?
Well, I think the record as to rehabilitation is based on the record. I mean, you are reviewing the record in front of the Character and Fitness Board. So I don't know what else to tell you about that. And we don't actually know. There is no evidence as to whether or not she has used drugs in any way, shape, or form, or alcohol since that date. There is no record before you.
Your time has expired. Thank you.
Thank you.
Mr. Hopwood, you have just under 10 minutes.
First thing I want to address is the standard here is not arbitrariness. The court here owes no deference to the board. The standard is simply whether the court believes Ms. Simmons has the present character and fitness. However, if you look at the board majority opinion, I agree. They lay out all of the factors. It looks very comprehensive until you get to the last 2 pages of the reasons why they deny her. One is the lack of time, which again, this court provides no deference to the board on that question. And the second is this sense of entitlement. And I don't think that the court, or the board for that matter, should be basing such a weighty decision on something that is incredibly subjective. And here, Ms. Simmons, I want to briefly address the 2005 drug abuse issue. Her drug abuse and substance abuse was not a question that was on the bar application. That's why she didn't address that. When she comes into the hearing, she says, I didn't think I was an addict in 2005. I didn't think I had a problem. I now know that was wrong. I know now that I was an addict even back then. And I would refer the court to pages 110 to 113 in the hearing where she actually addresses this and not just the board's findings on that point.
But counsel, we don't have to find that the board was arbitrary to rule in favor of your client.
That's correct. That's correct.
So when Ms. McElroy asks us to find that the board did not act arbitrarily, we can just reach a different decision.
That's right.
And respect them for having a difficult job that they did. They made their recommendation. Ms. Simmons has exercised her right to ask for review, which we would have reviewed anyway, and now we're in a position of looking at the record and making a decision that the court feels is the appropriate one.
And I agree, and I don't think the board can be faulted for how they weighed how much time is time enough, considering that there are 32 factors and sub-factors. The court's not given a great deal of guidance about which ones are most important, and at the end of the day, I think this court has to be the one that makes that decision and provides guidance to the board going forward, so the board knows what level of rehabilitation will outweigh the prior misconduct.
Can you address in terms of time the argument about the statistics on success, either for substance abuse recovery or criminal recidivism, and talk about that in terms of Ms. Simmons' own history of periods of sobriety followed by relapse or periods of crime-free living followed by reoffending?
And all of those times where she fell under the throes of drug addiction, it was because she'd not received treatment for the drug addiction. She doesn't receive the treatment till 2011, 2012. Since then, she has had randomized drug tests that she has paid for. It's undisputed. I don't think the board disputed the fact that she has been clean and sober for 6 years now. And so I do think this court should consider that. I also think the court, when looking at her 20 years of prior misconduct, I don't think the court should give much weight to the things that she did as a juvenile. You know, people that are 16 years old don't have the character and fitness necessary to practice law, which is why that should not be given a great amount of weight by the court.
Counsel, one of the things that caught my attention was that for each of these kind of falling off the straight and narrow, there was a reason. So there was an accident or there was a traumatic experience. We all know that the practice of law is very stressful. Things happen all the time in the practice that could be triggers to leaving the straight and narrow. What would you point to for us to look at to think that she won't again be a victim of circumstance, if you will, and given the stressful nature of what we're going to be asking her to do, she won't depart the path?
Justice Madsen, I'd point to two things. One is she has a record. There is in the record great evidence about this support community that she has assembled to help her with those issues. You have testimony from two people that worked with her hand in hand in Rule 9 practice of law and said that she was able to overcome any stressors. And then again, nothing will probably be as stressful for Ms. Simmons as this entire process in which she has not relapsed and she has reached out to her support community. And that's the difference now between her present character now and how she was in 2011, how she was in 2005, and 2001. She's received adequate treatment, she's taken active steps in her recovery, and therefore the board should have a lot of confidence that she will be able to handle the stress of the practice of law. The bar says that because bar counsel makes no decision at the end of the proceedings, this is not adversarial, but I don't think that you should take that at face value. I know from my hearing, and I've heard from people in other hearings, that bar counsel often makes clear how they feel in every question in their cross-examination and how they deal with the applicant before the hearing. So at the end of the hearing, when the board says, do you have a recommendation, simply not making a recommendation doesn't make this process any less adversarial for the applicants. If rehabilitation is the touchstone of present character, which I think this court should hold, then Ms. Simmons really makes, her record of rehabilitation makes this an easy case for the court. Character is not static. People change, and the law should recognize that. And I think it would engender great respect for people that are communities that are overrepresented in the criminal justice system, but very much underrepresented in the legal profession, to know that this court cares about rehabilitation and values that over prior misconduct. For those reasons, we ask that the court find that Ms. Simmons has the present character and fitness necessary to practice law, and that you allow her to take the bar exam and one day become a member of this great profession. Thank you for your time.
Thank you, counsel. The court will be in recess for 10 minutes.